guaranteed to the individual. The rights established are personal rights. It is therefore no answer to these petitioners to say that the courts may also be induced to deny white persons rights of ownership and occupancy on grounds of race or color. Equal protection of the laws is not achieved through indiscriminate imposition of inequalities. Nor do we find merit in the suggestion that property owners who are parties to these agreements are denied equal protection of the laws if denied access to the courts to enforce the terms of restrictive covenants and to assert property rights which the state courts have held to be created by such agreements. The Constitution confers upon no individual the right to demand action by the state, which results in the denial of equal protection of the laws to other individuals. And it would appear beyond question that the power of the state to create and enforce property interests must be exercised within the boundaries defined by the 14th Amendment. The problem of defining the scope of the restrictions which the federal Constitution imposes upon exertions of power by the states has given rise to many of the most persistent and fundamental issues which this court has been called upon to consider. That problem was foremost in the minds of the framers of the Constitution, and since that early day has arisen in a multitude of forms. The task of determining whether the action of a state offends constitutional provisions is one which may not be undertaken lightly. Where, however, it is clear the action of the state violates the terms of the fundamental charter, it is the obligation of this court so to declare. The historical context in which the 14th Amendment became a part of the Constitution should not be forgotten. Whatever else the framers sought to achieve, it is clear that the matter of primary concern was the establishment of equality in the enjoyment of basic civil and political rights, and the preservation of those rights from discriminatory action on the part of the states based on considerations of race or color. 75 years ago, this court announced that the provisions of the amendment are to be construed with this fundamental purpose in mind. Upon full consideration, we have concluded that in these cases, the states have acted to deny petitioners the equal protection of the laws guaranteed by the 14th Amendment. Having so decided, we find it unnecessary to consider whether petitioners have also been deprived of property without due process of law or denied privileges and immunities of citizens of the United States. For the reasons stated, the judgment of the Supreme Court of Missouri and the judgment of the Supreme Court of Michigan must be reversed. Reversed. End of Shelley versus Kraemer, a decision of the United States Supreme Court.